Welcome back to another edition of Between Two Fars. I am here once again with our poster children of MAP, our dynamic duo that were put together from across centers, a center in Maryland and a center in California, joined forces to make a wonderful pairing for some very complex, long-standing ASBCA litigation. I am proud to introduce Dave Schuman and Paul Kim, who are here today to talk to us about their experiences in their recent ASBCA litigation. Today's topic, the privilege log. Maybe something that you haven't given a lot of thought to, but these guys have been through the war and they have some stories to tell. Why don't we get started with you, Paul? What is a privilege log? Just high level, what's a privilege log?
Yes, so there's a phase in litigation called discovery, where you have to produce your evidence, document, and in the modern era, that's typically documents and emails and electronic documents. And the default rule is you have to produce everything that's relevant or could lead to relevant information, except if it's privileged. And so some common privileges are attorney-client privilege, there's spousal privilege, there's patient doctor privilege. I'm sure all of us have studied that for the bar exam, but you're allowed to withhold evidence from privilege. A lot of times those privileges can be used abusively by lawyers that don't work for NASA, because everyone at NASA is above reproach. But oftentimes, I'm pretty sure it's not an official rule of evidence, but it is definitely widely practiced that litigants will demand a privilege log from each other. And it'll say, okay, you're withholding a bunch of evidence that's relevant on a basis of privilege. We want an itemization of it. And that's exactly what a privilege log is. Yeah. It's an itemization of every single email that's withheld. And you have to give some metadata, the date of the email, the date of the document, who the document is between, and some basic high-level information as to what the document pertains to.
Yes, you referred to the privilege log a little bit earlier in our conversation as a powerful tool in the war of attrition. And that's exactly, I think, in a nutshell, is what a privilege log is. So when do you need a privilege log?
You know, a lot of times it's to just increase the litigation cost for the other side, because often all the privilege log does is generate a lot of fighting and motion work, and rarely does it go to the heart of the case. It did so in our instance, and I think Dave's going to talk about it. But anytime you feel that the other side is not being honest with its production, you just kind of want to feel it out, like, hey, are you withholding a lot of these documents pursuant to privilege, or you just kind of have to use your gut. A lot of the times, it's just often as a matter of course. Like, I'm thinking from my litigation experience, you plan to prepare it because both sides are unreasonable in litigation, and you just demand it because it's going to annoy the other side, and then they demand it against you. And
well, in all of this, is there some room for negotiation, especially early on, maybe before it gets too bitter? What are things that attorneys can do in reaching out to the other side to maybe mitigate the need for a privilege log, or maybe mitigate the burden of a privilege log?
Yeah, that's a good point, is to meet with your opposing counsel and set some rules, such as, hey, can we agree that any email where attorneys are CC'd, we won't produce those, and you can set some ground rules. Oftentimes, parties are not reasonable during discovery, but in those instances where you can't come to agreement, it's a huge cost savings, because having to produce a privilege log is extremely time consuming.
Yeah. Well, Dave, what happened in your case that really pushed you to the point where asking for a privilege log made a lot of sense?
Right. So the best way to have a privilege log is never to need one. But again, it's a tool somewhat akin to subpoenas for leverage. And in our situation, we wanted particular answers in written discovery to particular questions, and we wanted particular documents that we thought were highly relevant, and the other side was simply not producing them. Finally, relying upon a privilege I had not come across in my practice called the common interest joint defense privilege, which generally protects communications between two parties on the same side of a case. So we had a prime contractor and a subcontractor, and they refused to provide us any documents on a particular subject that they argued were discussing subjects common to the joint interests of both of those parties. Interestingly, in our case, the two parties were engaged separately in litigation in federal court, which is probably the subject of another discussion. At the same time, our contract was going on. So they were at odds with each other for a good long time. And then magically, one day, they were not at odds with each other. So we asked for an indication of the date when the common interest joint defense privilege arose. Very straightforwardly and honestly, okay, you're claiming this privilege, tell us when it arose. They refused to even answer that. So my wonderful colleague, Amber Huft in our office at Goddard said, you know what, just ask them for a privilege log on this subject, and that will force them to provide communications, at least at a meta level, like Paul said, on this subject. So we asked for the very specific privilege log on that subject. The other side, for whatever reason, made a mistake and produced a privilege log, which is 76 pages long with hundreds and hundreds of entries on every subject, not just the one that we asked for. In fact, there are no entries for that particular subject, which I find just absolutely fascinating.
All right, well, let's stop there for a second. They sent you an erroneous privilege log. They sent you something. What are the factors you think that created a situation where you'd get a privilege log like that? Is it easy to put together a privilege log?
Right, it's a royal pain in the neck and very expensive and very time consuming. And as Paul touched on, or we touched on in our discussion, if you request from the other side professionally and politely, you will be certain to get a similar request very soon thereafter. And practice tip here, huge labor saving device. It's very good to have professional and polite communications with counsel on all subjects throughout the litigation, but particularly with respect to discovery. If you can agree with opposing counsel that neither side is going to request attorney-client privilege communications, for example, and just take that off the table, that will save a huge amount of work. So we did, in fact, reach that politely and professionally agreement with opposing counsel. So NASA did not have to turn over any attorney-client privilege communications. In our discovery review, we did come across 3 or 4 documents out of 100,000 that were covered by privilege. And I told the clients, look, if it's not life and death important substantively to the case, let's just turn it over. It's not worth making a big deal about it. And this turns out to be excellent practice with respect to a privilege log, because in our situation, while the other side spent probably 2 months and countless hours and time and expense to produce this huge privilege log, they of course requested one from us a week later, and I responded back the same day, we don't have any. Because we hadn't withheld any documents, no privilege log to produce. But it works both ways, of course. And because we had already reached this agreement that all the attorney-client documents were not part of discovery, we didn't have to produce a privilege log on that. So it's wound up being very efficient. So, you know, this is a bigger subject, but whatever you feel about the merits of the case, it's still good to have as much as possible professional and polite communications with the other side to help achieve your objective.
All right, so it sounds like if you can get some agreements early to mitigate the cost and the burden of doing a privilege log, that's a win for both sides. If you can remain cordial, you're likely to be able to continue to have exchanges that are beneficial for everybody. But now you've got this privilege log here. What happens? Let's say we've got a practitioner who's gone through the terrors of compiling privilege logs and is now getting a privilege log in from the other side, and it lands on your desk. What should you be looking for in that privilege log, guys? Can you give us some tips on that?
The privilege log can tell you very interesting information. Of course, for the privileged entries at a high level, it will not discuss in detail the subject of the conversations, but many times that's not necessary. You can learn a lot just from who the communication is written by, who it's to, what were the dates involved. In our particular case, anecdotally, One entire claim, we had two claims, one entire claim for $500,000 plus rested on the enforcement of a particular contract modification, which has at the end release language, standard release language that we've all looked at 100 times, that says this resolves all claims on this subject between the parties. I'm paraphrasing. No future claims on this subject will be allowed. The other side argued that that modification should not be enforced by the board. The board should disregard this modification as if it never happened because it was the product of duress and coercion. The other side was forced to do that. They had no choice. And it turns out the case law that Paul and I uncovered shows pretty clearly that if you're under advice of counsel in the drafting of a contract modification, it's very difficult to argue that you are forced to do something with no choices. Right? You're not some sole practitioner forced into a corner, gun to the head, going to lose family business and everything else. No, you had access as a large company to sophisticated legal advice, to explore all alternatives, etc. So conveniently, the privilege log in our situation showed very specifically that the client had constant communication with counsel from prior to the start of contract award all the way through modification number 2 and in fact all the way through contract performance. So without even knowing the details of these privileged documents, it went a long way to help us proving the substantive point. And that one document alone, went a long way to saving $500,000.
Paul, what are your takeaways?
Yeah.
When you get a privilege log, what do you look for?
You just want to get a general sense that it has the appearance of being put together properly. And it's really just a game because, putting together a privilege log pursuant to the rules and what the case law actually says will take an inordinate amount of time. And there's no client in the world that would pay the amount of hours it takes to do a privilege log properly, pursuant to the rules of privilege. And so a lot of times these things are put together sloppily, but there will be some good faith attempt to put it together. So you want to just do a quick read to see if you can glean something from the metadata. And it's just, you have to have good spidey senses to see if something looks fishy about the log. In our case, as Dave mentioned, an issue in the key issue was duress, and the case law says that if you have advice of counsel, that really speaks against you being under duress. And so the privilege log provided contemporaneous, detailed events as to when they engaged counsel. And so in our unique case, we were looking at every single date, and they did protest too loudly because I think almost every day of the hearing, the judge took about 30 minutes of argument from the other side as to why we shouldn't be able to allow the privilege log, because they knew we had them dead to rights, because their entire first claim is based on their client being under duress, while at the same time they were under constant advice of counsel. And so they fought it a little bit too hard and drew too much attention to the fact of the privilege log. Yeah.
So you heard it here, guys, from our dynamic duo of Dave and Paul. The privilege log is a powerful tool in the war of attrition. But remember, with privilege logs, turnabout is fair play. And if you ask for one, you better be prepared to give one as well. Thank you so much for joining us today. Join us again when we're going to talk some more ASBCA litigation with Paul and with Dave. See you next time on Between Two Fars.